Assalamualaikum and good morning everyone. This debate will come to order. The resolution before us today is whether the directors should not be accountable for liability of his substitute directors. Representing the proposition or the government team are its first speaker, Fadzidahtul Ardianah, the second speaker, Athirah Hamid, and the third speaker, Kritigeswari. Representing the opposition are its first speaker, Najjat, and the second speaker, Intan Shazlin, and the third speaker, Nurul. On behalf of the House, I would like to express a sincere welcome to our special judges, Prof. Zuhairah and Dr. Hartinie, and I, Fareeq Zakwan, as your moderator for today. Each speaker will deliver a 5-minute constructive speech. Either the first or second speaker of each team will also get a 2-minute reply speech. Points of information will be allowed during the constructive speeches only, but not during the first and last minute of the speeches. The timekeeper will bang the desk after the first minute and again with 1 minute remaining to signal the time during which points of information may be raised. For instance, after each agree, I will immediately call upon the next debater to begin his address. There will be no points of order or no points of privilege. Heckling is also prohibited. Are there any questions regarding the rules? I call upon the first speaker, Fadzidahtul Ardianah, to introduce the proposition case for 5 minutes.
Evening to all, to the respected speakers, cautious timekeeper, honorable judges, members of the opposition team, and members of the floor. Before I put forward my case today, I would like to define today's motion, which this House believes that the director should not be accountable for the liability of their substitute directors. According to Section 2 of the Contracts Act 2016, defines director as any person occupying the position of director of a corporation by whatever name called and includes a person in accordance with whose directors or instructions the majority of directors of a corporation are accustomed to act and alternate or substitute director. Meanwhile, a substitute director is a director who is appointed to act as a deputy for another named director and as a substitute in the absence of the director, which means a close reading of Section 180 of the Companies Act suggests that the position of the substitute directors is a permanent one. The exact wording is a company may appoint substitute director. Ladies and gentlemen, my beloved speakers, it is important to note that the substitute director is not counted as director for the purpose of the official count of the number of directors that a company has. So if in the constitution of a company a company cannot have more than 5 directors, the substitute director is not counted for the purpose of determining the minimum and the maximum number of director of the company, which means the Companies Act considers that a substitute director as being one and the same as substantive director. In other words, the office of the substitute director are present at the same meeting. The substitute director shall not be counted for the purpose of the meeting of any quorum requirement. Also, a substitute director cannot vote for a meeting of directors or committee of directors at which the director for whom the substitute director represents is present. It is worth pointing out that the absence of a substantive director, the substitute director is considered as a full director and is to be appointed and removed in the same way as the director of a company. The Companies Act also points out that a substitute director does not stop being a substitute director simply because a substantive director has ceased to be a director. Ladies and gentlemen, this point is another confirmation of the fact that the position of the substitute director is permanent. Members of the hall, my first point is the director's duties are imposed on directors individually. A director in breach of any duties would be personally liable to the company. However, should not be liable if he already did all of this duty. The Companies Act 2006 imposed an array of obligations of a director. Some are personnel in nature and are specifically addressed to the directors. Other arise from the responsibility of the director to ensure that the company carries out its obligation, where both the company and the director may face liability in the event of failure. Potential penalties, ladies and gentlemen, depend on the specific obligation. Breach are typically involve a fine, or rarely for these more serious offences only imprisonment. Probably the most significant are the duties of the directors relating to the preparation, content, circulation, and filling of the company's annual reports and accounts, where many of the obligations fall directly to the directors. Some other key obligations relate to the restriction and condition placed on transaction between a director and his or her company, and loans made by the company or to the director. Broadly speaking, ladies and gentlemen, each director has the same obligation and accountability to the company, in that company law does not explicitly distinguish between executive and the non-executive directors. However, the legal test of directors' duties can involve both subject and objective elements. So in practice, the standard of care expected to each individual director may vary based on the director's office health and the specific responsibility within the corporation, as well as the circumstances of the corporation itself. Directors' duties are imposed on directors individually again, and Malaysian courts will scrutinize the conduct of directors individually in assessing whether or not each individual director has fulfilled their duties, which means these duties are all individually. Where several directors are liable for a default, they are jointly severally liable. Directors owe a duties to the company and not, as general rule itself, to its shareholder. This means any action against the directors must be brought by the company itself. However, where the directors themselves control the majority of shares in the company, they will not permit an action to be brought to the company's name. In this case, the court will permit minority shareholders to bring an action in the company's name in limited circumstances. However, in employment tribunals, claims involving discrimination against employees, a director may find himself or herself being sued personally alongside with the company. Ladies and gentlemen, the directors may be personally liable if they fail to meet their responsibility, as such as a breach of the director's general duties owed to the company, including the account of company or for profits made from transactions where a conflict of interest was present or did not declare an interest as required. Failing to comply with specific duties such as making unlawful distributions and any false or misleading reports in which the company suffer a loss. Ladies and gentlemen, members of the hall, moving on to my second point of the resolution, as referred to section 289 clause 3 of the Companies Act 2016, whereby this particular provision enables a company to indemnify an officer of the company, including the director, for any cost incurred by him of the company in respect of the proceedings that relates to liability or omission in his capacity as an officer, or the judgment is given in his favor, or he being acquitted or present granted relief by provision of Contracts Act 2016, or where proceedings were discontinued. As the responsibility of officers and directors in particular increase, so are the liabilities and risks that attach thereto. So a director may want to get protection from liability through the insurance scheme that will keep him indemnified discharge of his duties.
Speaker, you have 1 minute left.
All right. So we can construe that from the above in the fact that director in breach of any duties would be personally liable to the company. However, should not be liable if he already did all of these duties, and section 289 clause 3 of the Companies Act, whereby this particular provision enables the company to indemnify an officer of the company, includes director. Therefore, as a conclusion, the government strongly agrees that directors should not be accountable for liability of his substitute directors. Thank you.
I thank the member for her remarks. We shall now hear the first speaker for the opposition.
Assalamualaikum and good evening to the respected speaker, cautious timekeeper, honorable judges, members of the government team, and members of the floor. I would like to define our motion for today is that we strongly believe the director should be accountable for the liability of their substitute directors. Generally, a company director is appointed to manage the day-to-day business activities and finances and to ensure all statutory obligations are met. So, as a director, the appointed person shall manage all the business affairs of the company with a view to promote not his own interests but to give his best judgment in the interests of the corporations in all matters in which he acts for it without any hostile interest in himself or others. So, as a director, we believe that it is pertinent to be aware of one's responsibilities and liabilities, particularly the ones that has been statutorily laid down under Section 213 of the Company Act 2016, where under this provision, it requires a director to exercise reasonable care, exercise his power for a proper purpose, skill and diligence, and also act in good faith in the best interest of the company. So it must be noted that in comparison with the now repealed Companies Act 1965, the new Companies Act 2016 imposed heavier fines and longer terms of imprisonment on directors for breaches of director duties. For example, under the Company Act 1965, the improper use of property and position by a director to gain benefit for himself or to cause treatment to the company will only result in the director to be fined RM3,000 ringgit and imprisonment of up to 5 years. However, under the new Company Act 2016, the directors can be punished for up to 5 years imprisonment and fined RM3 million upon both convictions. So with the amount of fine increased by 100-fold, it serves as a stronger deterrent against improper behaviors and practice by the directors in causing wrongful loss towards the company. So based on this provision, we know and we acknowledge that it must be something heavier, the duty of the directors. So before I proceed with the first point, I would like to rebut the first speaker of the government, where the point said that the directors' duties are imposed on directors individually, because, like I mentioned earlier, a company may indemnify the directors in respect of certain proceeding brought against by the third parties. So an indemnity can potentially cover both the cost of the claim itself and the cost involved in defending it. So being a director will undoubtedly put you in a position where you will owe wide general duties to the company. So surprisingly, such duties would even include the need of having to disclose of the wrongdoings of others towards the company in which you are aware of it. So in other words, a director will not be able to feign ignorance or turn a blind eye to the wrongdoings being conducted against the company. So where in the event of a director is found to have done so, they may be found liable for being willfully blind to such misconduct, as they have a duty to act in a good faith and in the best interest of the company. So I support my point, my argument with the definition of the director itself, where it clearly includes substitute within the meaning of director. Section 2 of the Company Act 2016 provides that director includes any person occupying the position of a director of the corporation by whatever name called, and includes a person in accordance with whose directions or instructions the majority of directors of a corporation are accustomed to act, and alternate or substitute director. So a director is not necessarily defined by his designation as such, but rather by the dominant of controlling role he plays in managing the company. So we see that the director must have all the control, includes the liability for their substitute director. So therefore, we would like to strongly emphasize that we believe a director is not necessarily defined by his designation as such, but rather by the dominant or controlling role he plays in managing the company. So we believe that the director should be liable for their substitute directors. So I would like to pass to the second speaker of the opposition.
Thank you, Anis Najwa, for your remarks. I now call upon the second speaker from the government side.
Thank you, Mr. Moderator, and a very good evening, I bid to all. The opposition side may come up with an argument regarding whether a director should be accountable for the liability of his substitute directors. As you mentioned in Section 2 of Companies Act 2016, director includes any person occupying the position of a director of a corporation by means a director is defined by the role he plays in managing the company. The definition mentioned that both directors have the same duty, in which I believe that both director has to act accordance with their authority given to them. Every director, including substitute director, should be responsible for their own act or any decision that they make. The substitute director also has an equal obligation or the responsibility that a director has. So, in accordance with the Company Act 2016, a director should be liable for his own act or mistake that affects the company. The same rule applies for substitute directors, that they should be responsible for their own negligence and not to drag third parties into their problem, including the director. I believe that the director could not be accountable for something that he was not responsible for. Ladies and gentlemen, the government would like to strengthen that the business judgment should be applied if the director has duty of business and act in good faith in making business judgment rule. Where the business judgment rule applies, a director will be not held responsible for a decision, even one that is irrational and result in a loss to the company, as long as the director was not grossly incompetent. A director's business judgment can be used as a shield for directors who believe that they are acting in good faith in the best interest of the organization. Based on Section 214 of the Company Act of 2016, defines the obligation of director to exercise independent judgment, and this section allows director to exercise independent judgment and not to fetter their discretion under anybody control. They owe their responsibility to the organization and not to any person. They must only function and monitor the company's need and affairs, and they must always use their independent judgment in the best interest of the company rather than in the interest of any other individual. According to this section, a director must use independent judgment. According to the case of Farming Rights Society Limited and Secretarial Syndicate, the court held that if a corporation is established for the intent of performing a wrongful act, or if when formed, those in charge directly order that a wrongful thing is done, the person as well as the company are responsible for the consequences, although there is no proof in this case to determine responsibility under any of the duties of the director. The director should not be held accountable for the substitute director because it is the substitute director's responsibility to use the business judgment before making any decision or taking any risk. So the government strongly believes that a director or a substitute director should be held responsible for their own decision and any risk that they take. Thank you.
I thank the member for her. I now call upon the second speaker for the opposition, Intan Shazlin.
Thank you, Mr. Moderator, and good evening, ladies and gentlemen. I, as the second speaker from the opposition team, will elaborate on why directors should be accountable for the liability of their substitute directors. But before I begin with my point, I would like to rebut the second speaker's point from the government team, where she mentioned that a director's business judgment can be used as a shield for directors who believe they are acting in good faith in the best interest of the organizations. If the directors acted in good faith, they should have monitored their substitute directors even when they can exercise independent judgment. But they still need instructions from the directors, and therefore why I think that the directors should be accountable for the liability of the substitute directors. And moving on to my point, which directors should be accountable for the liability of the substitute directors. Based on the definition of the substitute directors, they will act in accordance of instructions from the director. And I would like to quote that according to section 180, It stated that the positions of the substitute director is a permanent one. The Companies Act points out that a substitute director does not being a substitute director simply because the substantive director has ceased to be a director. This means that the positions of the substitute director is permanent. Companies Act also considers the substitute director as being one and the same as the substantive director. Thus, it means that the substitute director is just an appendage of the main director and does not have an independent standing. A substitute cannot vote at a meeting of directors or committee of directors at which the director for whom the substitute director represents is present, but it must be noted that in the absence of a substantive director, the substitute director is considered as a full director and will be appointed and removed in the same way as a director of a company. Supported in the case of Malaya Banking Berhad against Green East Enterprise Sdn Berhad, when the court found that there is nothing in writing to evidence any agreement by the plaintiff as to discharge of the third defendant as guarantor, and the name of the third defendant still appear as the guarantor, thus she is held liable in respect of the guarantee and was ordered to pay for the plaintiff. Thus, based on the discussions above, it can be argued that substitute directors hold the same positions as the substantive director in the absence of substantive directors, and he has the same power and duty toward the company. Hence, if the substitute director breached his duty or not acting in the best interest of the company, the director should be liable for his substitute director's liability. Thank you.
Thank you, Intan Shazim, for your remarks. Now I call upon Kritigeswari as the third speaker for the proposition team.
Good evening to the respected speaker, timekeeper, as well honorable judges. So I would like to rebut the point that mentioned by second speaker from opposition, where she mentions that regarding the usable of section 180 from Company Act. When we see actually section 180 is mentioned about the power of court in relation to certain irredeemable debenture, in which section does it explain the position of substitute director is a permanent position. So when the second speaker mentions that substitute director is a permanent position, it means that if the position of substitute director is considered as a permanent, it actually goes against the section 1964 subsection B, where it mentions that the minimum number of directors should not be included an alternate or substitute director. So when we refer to this section, actually it explains that substitute director is not a permanent position. So the applicable of section 180 in current topic is not valid. And we believe that actually opposition team mentioned regarding liability, which is under represent relationship between employer and employee. So when we mention regarding this vicarious liability, actually we should see that there are three elements should be fulfilled, which is wrongful act, special relationship, thought must occur within course of employment. So but when see under this topic, substitute director is a person who is nominated by another director to attend meeting or perform duties on behalf of the director. And a director may appoint a substitute director if the constitution of companies allow. In the general meaning, actually, substitute director does not specify or state that the person who may elect for substitute director should be employee of that company. It means that anyone who is not employee of the company can elect a substitute director. So when that situation occurs, actually there's no relationship of employee and employer. So an employer should not be liable for that employee's act or mistake. So it means that when the substitute director was appointed by someone who is not employee of that company, it means that there are no relationship or connection between them. So that director should not be liable for substitute director's mistakes. And I would like to, the government would like to conclude our rebuttal by saying that our second speaker mentioned regarding right and liability. So I believe that when the substitute director have the same right and liability as a real director, so I also believe that the substitute director also should be liable for his own mistake and not by sending that mistake to director. I mean that director should not be liable for mistake that done by someone else, even when we know that actually substitute director should bear the liability and right as a normal director. So that's all.
Thank you, Kritigeswari, for your remarks. Now I call upon Aina Shaza as the third speaker from the opposition team.
Thank you, Mr. Moderator. A very good evening, I bid to all. The opposition side may come up with an argument regarding whether a director should be accountable for the liability of his substitute director. Generally, an individual is held accountable for his actions. However, in situation where there is a relationship between an employer and employee who is charged with duties to be performed on behalf of the employer, this idea is based on the maxim of qui facit per alium facit per se, which means he who works by another acts for himself. Ladies and gentlemen, members of the hall, when assessing a master-servant relationship, this rule often serves as an assumption. The master is held responsible for all actions committed by his servant while on the job. The reason for during the course of employment is that the act should be performed as a servant on behalf of his master and as a matter of obligation. The reason for the vicarious liability was held in the case of Barwick against English Joint Stock Bank, where the fact that this case, though the master has not authorized the acts of servant, however, he has appointed him to do the class of acts and hence answerable for how his servant conducted himself in exercising the duty. The directors serve as the company's representatives in handling and transacting business, as well as trustees of the company's properties. The company that they are represented is found vicariously accountable for their actions whilst on the job. Similarly, the directors are personally responsible for actions taken in the name of the company. Next, I would like to rebut on the point by they are mentioned by third speaker. Based on section 1996 clause 4b, substitute director is not counted as a director for the purposes of the official count of the number of directors that a company has. So as an example, if company A stated in its constitution that a company have more than 5 directors, the substitute director is not counted for the purpose of determining the minimum and maximum number of directors of the company. Companies Act also considers the substitute director as being one and the same as the substantive director. Thus, it means that the substitute director is thus an addition of the main director and does not have independent standing. With that, I believe that the substitute director holds the same position as the permanent director in the absence of permanent director. So if the substitute director breaches his duty or does not act in the best interest of the company, the director should be liable for the substitute director's liability. Therefore, we on the opponent side firmly agreed and believes that the directors shall be liable for substitute directors on 3 grounds, which are that the definition of director clearly includes substitute within the meaning of director. Based on the definition of substitute directors, they will act in accordance with instructions of the director and the vicarious liability applied. Thank you.
I believe that's the end of our debate discussion today. I thank the member for concluding the debate. Will the judges please complete your ballot? After doing so, you are invited to make constructive comments, but I would like to remind you that you are not to indicate which team has won the debate. From this debate, we can conclude that the directors should not or should be accountable for liability of his substitute directors depending on the circumstances as stated by our speakers, regardless from the government or the opposition team. I, as moderator, apologize if there are any mistakes in speech or behavior, either intentionally or unintentionally. Thank you for your attention and see you next time.